Good morning, everyone. I'd like to commence the quarterly commission policy meeting on March 14th. And in the absence of the vice chair who chairs this committee, Judge Marsico at the moment, we're waiting for him. I'll ask the chair, Representative Krajewski, how he'd like to proceed. I'm more than happy to run this policy section if that's okay with him.
Yes, good morning. That is all right with me, Matt. So you have the floor until Judge Marshako comes in. Do we have an ETA for him?
We do not at this time.
Okay, I can contact him in the meantime.
Great, thank you. And for purposes of just the record, in person here today with us are Professor John Rago, Judge McLaughlin, Judge McDermott, our counsel, Professor Mystic. We also have commission members D.A. Bible and Mr. Balkovic. We also are joined by our ex officio members, Chairman Fox and Secretary Harry. So welcome. And just before I begin, this is my first official meeting as executive director, and I just want to thank the chair and the vice chair, Professor Mystic, and PCS staff for assisting with the transition. Their insights and support have helped ensure a continuation of high-level engagement with the various roles and responsibilities of the commission. So with that, we have a pretty full agenda here on the policy meeting today. We're going to, as we've noted throughout the last few meetings, we're at a great time here at the commission where we've enacted a number of policies here in the Commonwealth. And really our focus now has been on implementing, especially the 8th edition guidelines, parole guidelines, and other policies. And so today I'd like to spend a little time briefing you on those efforts. Staff will be talking about information they've received in the field from their trainings related to the 8th edition guidelines, get an update from the Applications Information Technology Unit on the development of our next gen application to replace the SGS web application, also about efforts to update the legacy application to make sure it supports the 8th edition guidelines, hear from the Research and Data Analysis Unit on how risk assessment is being used in the field, and get some discussion about sentencing risk assessment, revisiting how additional information is or is not being requested and obtained by judges prior to sentencing. And then if time permits, we'll talk about a Senate resolution that has not been adopted yet, but that requires the commission to do a thorough study of veterans specifically related to post-traumatic stress disorder and post-traumatic stress injuries, and the impact it has potentially on sentencing, as well as what programs are relevant and available from pretrial through post-sentencing, including things like veterans treatment courts, and then what programs are available to Department of Corrections, local jails, probation, et cetera. But again, that will be time if we have time for that. So I just want to start the meeting by talking about, we have some new members, which we'll introduce formally at the business meeting, but to talk about what we have in addition to this committee, these standing committees that the commission has. So one standing committee is in fact this policy committee, and the policy committee is made up of all members of the commission. And the role of the policy committee is responsible for review of sentencing, correctional and parole statutes, and coordinates the development and review of modification of guidelines and policies. Historically, since I've been with the commission, this policy group has really wrestled with things like sentencing risk assessment, domestic violence pretrial risk assessment, specifying the components of the 8th edition guidelines, such as classification of offenses into offense gravity score, what the prior record score should look like, and et cetera. So this is really a forum for us to talk about those policy decisions as a commission at large. In addition, there are a number of subcommittees. And I'll just walk you through these subcommittees about the roles and responsibilities. And these committees if this is the correct word, have gone a little stale, meaning that the idea is to meet midstream between each quarterly commission meeting for staff to engage with commission members on important topics that would inform us heading into the commission meetings. Very few, if any, actually are meeting currently. And after this short introduction, I'll turn it to Ryan, who, when he was manager of the Education and Outreach Unit, would meet regularly with this subcommittee to hear a little bit about some of the value added that it might have. So without too much overview here, we have an executive administrative committee, and that is chaired by Representative Krajewski and does include all our legislative members. It's important to note that these subcommittees only include 5 members. If we have more than 5, then there's a quorum and we would have to have it as a public hearing. So it's limited to 5 members. And the Executive Administrative Committee reviews the budget and personnel issues, reviews contracts, leases, and cooperative agreements with government agencies, contracting for services, personnel, and equipment required by the commission. And as I go through these, it may not be necessary for each of these subcommittees to meet quarterly before each commission meeting, but there will be sometimes I think that there's a higher priority for these meetings. The next group is the Applications and Information Technology Committee, which is chaired by Senator Street. Assists with the review of data collection via SGS Web, support and development of SGS Web modules and other applications, and of course, would be providing valuable insight into the next gen application, which will be incorporating parole guidelines and other aspects. I should note that many unit managers currently do provide the subcommittee, especially the chair, with a summary of activities in lieu right now of the actual meetings that are happening. But there are times, of course, it would be critical to receive valuable input before we convene the actual policy commission meeting. The Research and Data Analysis Committee review the commission's research agenda and data management, reviewing the preparation of data sets, evaluation, and research projects. So one could imagine the subcommittee reviewing reports before they're shared with the full commission to provide feedback, to think about a strategy for research design. If time permits today, thinking about that Senate Resolution 196, Unit Manager Brett Miller will be talking about the possibility of site visits, for example, to 4 or 5 jurisdictions. Be great to get input from a subcommittee, maybe even input and entree through a commission member to assist with us before we make those visits. That committee is chaired by Senator Langerholtz. The Education and Outreach Committee assists with the review of issues impacting current guidelines and risk assessments and related implementation matters, and oversees the education and outreach efforts, including monitoring compliance with guidelines. And that committee is chaired by Representative Bonner. And I should note that the listing of the committees are on page 19 and 20 of the commission notebook, with the assignments that have been made by the chair and the co-chair for where each member sits on one of these committees. So each member is on one of the standing committees and all members are on the policy committee. So with that, I'll turn it to Ryan to briefly discuss some of the value added these standing committees have provided in the past, with, again, a goal of kind of re-energizing the use of these and reconvening these when needed as we move forward in this year.
Great. Well, thank you, Matt. In my time with the commission, I've been in the education outreach space since I got to the commission, and the Education Outreach Committee has always been very active. And I'll give you some examples on how the subcommittee specifically can help staff and also bring information to the full commission. And I think of them as opportunities for, one, just staff to engage with members. Outside of our quarterly meetings, staff don't have a lot of engagement with our commission members, and these subcommittees really provide an opportunity to directly engage with those members. It's also important because it provides staff with an opportunity to ask for guidance in certain matters. As an example, the Education Outreach Unit fields, over, I probably can give the numbers later today, but, well over probably 1,000 calls and inquiries a year. And they can be pretty technical, and we want to make sure that we're communicating the correct information to practitioners across the state. And in the past, we've really used the education and outreach members as a conduit for us to say, what's the commission think here? Are we on the right path? Are we doing the right thing? And is this a matter that we should actually bring to the full commission in a policy meeting like this? And so we always used it that way. And another example in which the Education Outreach Committee really provided a lot of value, and this was over, the last 7 or 8 years, as the General Assembly would mandate the commission either to adopt a sentencing enhancement or more commonly and frequently create new offenses or modify existing offenses, staff are in a position to make some initial determinations on what the omnibus offense gravity score would be based on adopted policies by the commission. And we would use the Education and Outreach Unit as an opportunity the Education and Outreach Committee as an opportunity for staff to ask those members, is this the correct application of that policy? And so then we could bring that information to the full commission during a policy meeting and a business meeting. And over time, as you go back through and you think of all of the amendments that occurred to the 7th edition guidelines, we had a lot of detailed conversations around, one, the omnibus score for an offense, a new offense or a modified offense. But then more importantly, if the committee thought, well, that's probably, too low or maybe it's too high, that became an opportunity then for the committee as a whole and the policy meeting to discuss the actual correct OGS from the commission's viewpoint. So it's really an opportunity for staff to vet some of those issues, and then for members to, in their role, to say, yeah, that's not an issue that really needs to come to the full commission and everything's fine, or that's sort of novel and maybe we should bring that to the full commission for their discussion. And I found that to be really valuable over the years as manager of the Education Outreach Unit, in having that support from commission members, and so that we, again, make sure that we're just communicating the correct things to practitioners. And there's just other value added in it. I'll give you some examples, and this was more historical. And there was a time when the subcommittees and the lead staff were sort of seen as like a tandem pair at a commission meeting, where the lead staff for that committee would sit with the chair of that committee, and the chair would actually sort of open up the discussion during that unit's update and say, these are the issues that are faced in front of the Education and Outreach Unit. And then oftentimes the chair would just defer to the lead staff to provide the details of the update. And we got away from that, and that's not an issue, and I'm not necessarily promoting that we go back to that, but just to give you some perspective that we really saw that as sort of a close connection from a manager to the chair of that committee in providing information to the whole commission. And I think for staff, that was always something that was sort of helpful and appropriate use of commission members' time. So again, we've waned over time on the engagement of these committees, as Matt has mentioned, but in thinking forward here with the implementation of the 8th edition and all the efforts that we have ahead, not just from the education and outreach space, but from Christie's space in the applications and information technology, and then for Brett in research and data analysis in the future of just monitoring, how are the 8th edition guidelines being implemented? What's the impact of those? I think having, re-engaging those meetings and having those regular opportunities to inform commission members outside of a meeting would be really helpful, certainly from a staff perspective. But I'll assume this, but I'll say this and say that I think from a commission member standpoint, that would also be helpful for you to hear from staff in maybe a less formal meeting scenario. And then just from a technical side and the logistics, we used to do them conference call. Now, of course, we have, video conferences. And so I think it's a much easier lift for us to provide information electronically, meet for a very, specific amount of time. Typically 30 minutes to an hour has been what we target. We try to be very mindful of your time and that you're attending these quarterly meetings as well. So, as Matt mentioned, I think this is a nice opportunity for us as the commission has received new appointments and new members to just, reorganize and re-engage in this space. So hopefully those comments were helpful for our members.
Thanks, Ryan. Before I move forward, any questions about the standing committees and the role and why we hope to re-energize and re-engage with those subcommittees or standing committees? Okay, great. And as I open with, the commission is really focused on implementing and advancing a lot of support materials related to the 8th edition guidelines, both in training materials and in our web applications. And our research and data analysis unit is focused right now on monitoring and evaluating existing practices like the risk assessment tool. So this agenda this morning for the policy committee will really be a reporting out on a lot of those activities and what we're learning and seeing a path forward on a number of different issues. I think, one of the nice things has been discussed about the 8th edition guidelines. Obviously, they came effective on January 1st, but there are not going to be a lot of sentences imposed in the first few months because you need to be arrested, processed, and then sentenced, of course. So we have a little bit of a lag time that is providing us to field some continued questions from the education outreach and refine the materials that we're sharing, and look forward to some input on that from the full commission. So with that, I'll turn it over to Ryan and Bobby, who will talk about some initial lessons and questions that they've received in the field regarding interpretation or implementation of the 8th edition guidelines.
Thanks, Matt. So Bobby and I will take about the next, maybe 30 to 45 minutes and walk through, and I'd certainly open it up for any discussion on any of these topics. Before I go through the list of topics that I'd like to cover, I'd be remiss if I didn't say thank you to the Education Outreach Unit. So Bobby joined the commission in May of 2023, just after the commission adopted the 8th edition guidelines. And as we were gearing up, I told him this during the interview, so he came in knowing, but we were gearing up for a massive effort in which we are just in the beginning stages of. And we were coming off of a great deal of work over almost a 10-year period to move across the finish line, the host of policies in the 8th edition. But so I have to thank Bobby. He's been wonderful since he's joined the commission. He oversaw the scheduling of numerous sessions with the counties, and I have to also say to the whole Education Outreach Unit team, Jen, Education Outreach Specialist, has been with the commission the longest in the unit and has a lot of experience in providing sentencing and guideline training. So sort of took the lead from a staff perspective in getting out there. Tom Backenstow, who recently retired, carried the load too with Jen initially. We also had some newer members of the unit, Tiffany Smith and Krista Rubin, who jumped in right away and started handling sessions. And so, they really get the credit for all of the effort and all of the miles put on the commission fleet vehicles and all of the hours of trainings that they did. And I just wanted to note, those initial efforts, I really pushed for us to be physically in the counties for those and not do them remotely. And I think we were successful in a large way of deploying to the counties. And I think there's a couple of positives there. First, from a county perspective, in my experience over time here with the commission, they really appreciate when the commission comes out to a county. And it doesn't matter the size, but some of the smallest counties maybe appreciate it even a little bit more because you don't get out to them as much. And we're making sure that we're prioritizing every county. And then another takeaway that just from a staff perspective, I think, we have some new members in the unit, but they really benefit from being in the counties and learning and meeting the individuals because they become, the front-facing apparatus for the commission and engaging with practitioners across the state. And so I just wanted to say thank you to Bobby and his team. They've done a wonderful job, and I left out one person, but I wanted to also mention Maria Agello, who is our policy specialist. And while she didn't hit the road with the rest of the team, she was back in the office working on all of the details in the text with our former executive director and myself, working with the Pennsylvania Bulletin to publish all of these documents, and also building out a wealth of reference materials for practitioners across the state. So they've done a lot of work, and I get the privilege of just telling you what they learned here. So these are the topics for us to discuss here today. And again, I see this as some takeaways, just areas within the guidelines that we saw, that generated conversation, maybe generated opportunities for clarification, but really were sort of the areas in which we consistently, had more detailed conversations throughout the state. At the offense level, I'll talk about offense gravity score assignment. Some of this isn't technical. It's more just sort of organizational. How did the commission organize the 8th edition guidelines and the text of the guidelines? And how did we publish the information? What's the accessibility of that information to practitioners across the state? So I'll talk a little bit about that. I'll talk about enhancements when it comes to the offense related space, and I'll get in more detail there. When we move to sentence recommendations, clearly there's been a number of changes in the way in which the commission, or the recommendations that the commission is making. One area that's just visually different with the sentencing matrix for the 8th edition is the former county intermediate punishment, but now probation with restrictive conditions. It's not as obvious to some individuals on the matrix, and it's really specific in other areas. And so it just gave opportunities to, clarify for practitioners and also point to the text of the guidelines, the policies that the commission adopted. We'll talk about community service. This has been something that the commission has had from a sentence recommendation or guideline requirement for a number of years. But through this process, the commission really put more emphasis on making sure that that's part of the consideration. And we had opportunities to talk about that. And then we'll talk about reasons for sentence. And I know for the members that were part of the final adoption of the 8th edition, there was a lot of discussion around, putting reasons into the text of the guidelines. And just as a precursor, got a lot of discussion when we were in the counties. So I'll just sort of give you some updates there. And we'll get into prior record score, probably substantively the largest change in the 8th edition guidelines. Under the 7th edition, prior record score is a complicated beast in of itself. But our talking points have always been the policies were adopted in part to simplify the process. There were other reasons, but as you can appreciate that when you go out and you show practitioners a completely new matrix with more OGSs and a whole new prior record score scheme and say it's simpler, that sort of lands flat initially, and then you spend time trying to show them how we believe it will be simpler. So some new areas within prior record score, I'll talk about those as we go through. And then the final area that I wanted to talk about is the judicial proceeding recommendations. And that's, again, something, new to the 8th edition and did raise a lot of discussion. And again, a lot of this is just opportunities for staff to highlight the text of the guidelines, but also then with any of these areas, reinforce existing policies that have been in place, because not everything in the 8th edition is new. Right? A lot of the concepts remain the same, and we talked a lot about that in the sessions. While there are 30 general OGS categories, an OGS is still an OGS. It's linked to the conviction offense, so the concept of that isn't different. It's just that we are asking people to be able to count from 14 to 30 now, which is sometimes a heavier lift than in the past. But the focus of it really was, still much of the same. When it comes to the OGS assignments, this is really the first two bullets here are the first two main bullets that you see are really about the organization and some areas that created some confusion with practitioners and just where to reference information. So it was a teaching opportunity. My father was an elementary school teacher, and he always says, that's a teaching opportunity, Ryan. And so this was one of those where we just made sure individuals knew where to find the information and how the commission organized it. So I'll start by saying in the 7th edition, we in effect had one offense listing, right? 303.15. So burned into the brains of all of the education and outreach specialists. But in the 8th edition, there was an effort to sort of separate out the offense listings because we focused in on DUIs and BUIs a little differently than we had in the past. And so we have, from a structured standpoint, we have 2 offense listings in the 8th edition. And so it was really trying to make sure people understood when they looked at what is now the first offense listing, they see 303A.9, and they don't see any DUIs. They think, like, where did all the DUIs go? And we didn't remove them, but we just put them in a different place. And so there was some confusion initially there and just sort of the organization, because you do have some, Title 30 or Title 75 offenses, even though we think of Title 75 mainly for DUIs. But what we did do with 303A.10 was really reserve that for those BUIs and DUIs that have mandatory provisions. And one of the areas, sort of from an educational standpoint for practitioners, was just to note that when the commission worked through the assignment of offense gravity scores, particularly for DUIs, the effort was to align the offense gravity score to what otherwise would be the mandatory minimum for those offenses, because mandatories in those 2 areas for DUIs and BUIs really drive the sentences. And so for the commission to have what would seem like sort of an artificially low OGS would be superseded by the mandatory. And so we just worked to sort of bring the floor up if necessary to it. And so that was a big effort to sort of separate those 2 out. And so that was something that, you had to work through with practitioners across the state to make sure they understand when they're referencing the information that they have to, learn to look in 2 places. And then a decision that occurred during the publication of the 8th edition guidelines, and it was a decision made in part to sort of save some effort and some complication in the publication in the bulletin, these very long listing of offenses. I mean, they're dozens of pages long. So as the OGS assignments were made during the development of the 8th edition, any OGS that in effect would be equivalent to the omnibus OGS was not published in the Pennsylvania Bulletin initially. It saved, a dozen or some pages as an example. And then the idea was that when a practitioner would look at the offense listing, if they didn't see the offense, then the assumption or the presumption would be that it's the omnibus OGS. And it made a lot of sense at the time. And then we got out into the counties, and it was like people were calling and saying, where is this offense? Because they, and to the commission's credit, we've always done a wonderful job of publishing like every offense under the sun. And now we have all of these practitioners that are really accustomed to coming to our offense listing and seeing that information. And some of these offenses, as you can appreciate, would be relatively common offenses. And so we would be getting calls initially, or there'd be questions in sessions as folks were being diligent and looking through, and they couldn't find the offense. And so what we worked on from a reference sort of guide was to create an unpublished listing of offenses. So all of those offenses that were not published in the bulletin, but have the OGS that's equivalent to the omnibus, we have an unpublished list on our website so that people can reference that list. And that way they're seeing the item that they've been looking for. And it's been helpful, but it's another one of those things where we're just teaching folks how to work within a new system. And this is not something necessarily new. The commission has oftentimes had to publish a list of offenses when the General Assembly, creates a new offense or modifies an offense in between an amendment from the commission. So it's not that we as staff are acting outside of, I think, our responsibility. We're just providing a reference document. It's very clear that we've titled it clearly. There's footnotes that indicate that these are unpublished offenses. Their OGSs are equivalent to the omnibus, but individuals now can have that information to assist them in finding the correct offense gravity score. Sorry if that was too much for you, but I just wanted to give you that. And those are some of the examples of areas that we're working with as we go through with counties. The final thing that I wanted to mention here, and this came up in several sessions, and again, it's just another one of those opportunities for clarification for staff and communicating to practitioners, what was the purpose and the intent behind the policy. A lot of these early sessions that we did from mid-September through January, for the most part, were sort of twofold. It was to inform counties, why did the commission do what they did? And then what is the policy and how does it apply? And this is one of those sort of whys for individuals, because when you look at the offense listing for possession with intent to deliver, as an example, when the commission was going through the assignment of offenses for this, there was a lot of discussion about the weight categories that the commission has in the offense listing. And that's a commission, that's not in statute. The commission had created over time those weights sort of try to get this sort of, is it a dosage or more culpability or whatever it might be from a punishment standpoint. And what we discussed during the adoption or the development of the guidelines was, were these additional categories for these higher weights necessary? And in one, as we looked at the number of offenses that we received, we just don't have a lot of numbers of offenses in those higher weight categories, right? We just don't see them, particularly at the state level. And so there's not a lot to focus on there, but we had always historically sort of stepped up in OGS by these weight categories, maybe one OGS higher and so forth. But the discussion really was, and at one point, to collapse all of those higher weight categories into just, sort of one larger category and have a singular OGS for it. And that's sort of where the commission landed in the end. But what we didn't do was collapse the weight categories. And there's some benefit in us collecting data and information and understanding. As I give you an example here, is it like 50 to less than 100 grams, or is it 100 to less than 1,000 grams? But for practitioners, when they look at the offense listing, what they will see for all of those weight categories is the same OGS. And so it's just an opportunity for us to provide education to practitioners that, yes, it's the same OGS, and that was purposeful. But these are things that we can think about as we move forward in completing an implementation manual for the 8th edition guidelines, to provide in the commentary section some of these explanations behind the decisions that were made at the time of the adoption of the 8th edition. So none of this are issues. They're just, things that we're seeing from the field, and just wanted to bring to light should the commission be asked about it. Yeah.
Just to add what Ryan's saying, I think from the research and data side, there's always a tension about categorization, and in the world of data analysis, you can't unpack things that have been collapsed. So we have multiple categories that allow us to see if there'll be differences in practice when this is implemented, if we should consider a reassignment of OGS categories. For those who are on the commission, when we were working on the assignments, we spent a lot of time looking at these weights and looking at conformity rates, as well as types of sentences and durations of confinement for different weights. And we saw a lot of similarities, even though in the past we treated them differently. So right now, for purposes of OGS assignment, they're packed together, but for data analysis purposes, we're still collecting that information. So when we get to the phase where we have information from the guidelines, when we're looking at how it's working in practice, we can relate and look at that data. So that's a really important feature that we want to preserve, even though it may be confusing a little bit to practitioners. So there's a tension there.
Hey, so Matt and Ryan, just one quick clarifying question. I'm sorry if I missed this. I was just looking at the bullet point about the publishing offenses. Can you just explain again which offenses are published on the website and which ones are not?
Sure. And my apologies if I wasn't clear. So we have, as part of the text of the guidelines, that's all of the information, the formal text of the guidelines is what would have been adopted by the commission and published in the Pennsylvania Bulletin. And so on our website, we have the 8th edition text, and it's broken out by the sections, but it's all what was published in the bulletin. We reformatted it in a clean version, so it's nice to print into, a binder. This unpublished listing that I'm talking about is an internal list that staff of the commission created just to represent any of those offenses that are, the common offenses that we see that have the omnibus OGS. So there was that, decision made not to publish them in the bulletin because the sort of the takeaway was if they're not published, then they're the omnibus. But what we found was in working with individuals early on, it became a pretty common occurrence that they weren't finding the information that they were looking for because they were accustomed to seeing, these sort of general offenses that we frequently see in the system. And so it's not the way we organized it too on the website is it's not part of the text of the guidelines. It's a separate sort of reference guide for people, so that they can look at that and see that these were not published in the bulletin, but they would be equivalent omnibus OGS scores.
Okay, so there's a separate reference online that has those omnibus
Correct.
OGSs. Okay,
Correct.
got it. Thank you.
And I would just like to note that we do have our chair of the policy committee has joined us, Judge Marsico.
Better late than never. Sorry, I apologize. The trial of lawyers told me would be over early yesterday. It's still going on. So,
Oh, welcome. We're going to continue to move on if that's okay.
sure.
All right. So the next area, and I'm going to move through a little quicker here, but this is the sentencing enhancements. And I'd start by saying that as staff went around the state, and myself included, this was not an area of necessarily confusion in any of the policies that were adopted by the commission. It really was an opportunity for us to actually reinforce existing policies and the application of enhancements with practitioners across the state. And prior to going out, and in my experience with the commission, it's not uncommon that I've heard that enhancements are negotiated away, as an example. But the structure and the way the guidelines are framed, it's to say that if those sentencing factors that would render an enhancement applicable are determined by a preponderance of the evidence by the judge at sentencing, then that sentencing enhancement applies, right? That it's not to be negotiated away as part of the process. So it wasn't new to us that was a practice in place across the Commonwealth, but with the 8th edition and talking about enhancements and the way in which the commission defined sort of the two categories of offense specific enhancements versus general enhancements, and then the way in which they're applied through an adjustment in the OGS or a subcategorization, all of that was well and good. It just that the discussions became about negotiating away enhancements. And so it really became this opportunity for staff to remind the counties that that's not the appropriate use of the guidelines, that if the factors are present, the enhancement applies, and then the negotiations start from that new and enhanced standard range. And so as we went through, and there will be other examples like this, it was a great opportunity just for us to have those discussions with practitioners across the state. So I don't think there's anything that we took away from the enhancements other than to reinforce how you should be applying them. I think a positive is that from my experience, I think this is true of Bobby and the units, the way in which the commission organized a table of enhancements in the 8th edition text of the guidelines was really welcomed by practitioners. They just didn't always know what the enhancements were. And the commission continues to have more enhancements. I think we're around 21 enhancements now, but the table's really well organized. It tells a person what the enhancement is, the description of the enhancement. It tells the individual how it's applied, where they would need to go for additional information if they need it. So it was a really positive thing. But it was an opportunity for us to make sure that practitioners and the court as well understood like how this operates within the context of the guidelines, and to remind them that they can aggravate, mitigate, or depart from that recommendation. But just to make sure that, again, if those factors are present, the enhancement shall apply. Moving on to sentence recommendations. Probation with restrictive conditions. This was just an area to discuss with practitioners, where in the guidelines are the recommendations for probation with restrictive conditions. We're sort of combating 20 years of experience and comfortability. People are used to looking at, well, level 3, level 4 under the 7th edition. Where does that meet on the new 8th edition matrix? And so for the 8th edition matrix, one of the areas we're very clear to the counties are level C. That's the trade-off where we have county confinement, and we're very clear on the matrix that that's that sort of trade-off of county incarceration for a sentence of probation that includes restrictive conditions. So visually, you see that on the sentencing matrix under level B, it's also obvious where you see for prior record score 2, 3, and 4, you will see these recommendations where probation is included with restrictive conditions. And that gets to the intensity of supervision in the discussions that we had last year. So that was all, very obvious to individuals. But some of the areas that came up in discussion were thinking about, like, what about DUIs and some of these, a little bit more serious offenses, which would fall into level D of the matrix. That's that, state county confinement exception. And in the past edition of the guidelines, the commission might have been more, obvious in those recommendations, but as part of the 8th edition, that wasn't included on the matrix as level D. So visually, when you look at it, you don't see a recommendation for probation with restrictive conditions. The starting point for a level D offense is that it's a state prison sentence based on the place of confinement statute. And based on statute, there are opportunities for these county exception sentences. So that's sort of the focus of the recommendation. However, if the individual references the text of the guidelines, which is the long citation that I've included on the slide here, there is a reference in the text of the guidelines that, if appropriate and eligible, probation with restrictive conditions may be used there. So, it's just, as we work through with individuals, a lot of counties really tuned into, what about those sort of, offenses on the edge? And you can appreciate, if you look at a level D offense, the prior record score 0, OGS of 13 for level D is a standard range of 12 to 18 months. And for any third time high tier DUI, that's where they're going to land right there. And that's a really big target population for the use of probation with restrictive conditions across the state, in lieu of confinement. So again, just sort of informational and areas which we were able to provide, I believe, clarification for practitioners across the state.
Ryan, sorry, just another
Yep.
question on
Sure.
the probation recommendations. Just a general question. I'm curious about, given the recommendations of the commission around probation, how are you navigating any overlap or differences with some of the policies laid out in the Senate bill that was passed in the winter, 838? Because I know there are some differences, at least for myself, in kind of navigating them between maybe some of what's laid out in the legislation compared with the recommendations of the commission around probation. So just curious if that's come up at all in conversations, and if so, how that's been navigated. But maybe it hasn't been something you've encountered yet, but just want to ask.
Well, thank you. And just so make sure I'm clear, this is the probation reform that was recently enacted, correct?
Yeah.
So I think from a sentencing point of view and where I'm sort of focused here, I don't think there's been any conflict there. It's really on when there would be a failure on supervision and a revocation of that probation, and the limitations then by the new statute for those technical violations with a resentence to total confinement, which it's a good question for us to discuss when we talk about the commission's resentencing guidelines. And that's an area in which we're going to have to sort of look at what would be the differences in between those two, what the commission's resentencing guidelines recommend versus sort of I guess I'll call it the limitations placed on the court for options for resentence of technical violations. So I think for this space, Representative, I don't think we have any issues. But again, on the resentencing, I think that's an area for us to discuss at some point.
Got it. That makes sense. Okay, thank you.
Yeah, I agree with that the resentencing guidelines, I think, are where the focus is going to have to be on that. Maybe we should start taking a look. I forget when that bill's effective. I think June or sometime this summer, if I recall. And I know a lot of us are just getting up to speed on it ourselves. But yeah, that's a great point. Representative Krajewski pointing that out, because there is going to be some inherent conflict there, I think, with what the bill, now law, mandates certain restrictions on those resentences.
Yeah, I just looked it up. It says 180 days. So yeah, you're right, Judge. It'll be sometime in like June.
Yeah, it'll be June 11th
Okay.
of this year. And just as and I'm going to keep moving forward here in a moment. But just so everybody's aware, in the supplemental materials for the commission meeting, on page 84, we have a recently enacted legislation summary of Act 44 of 2023, which is what we're talking about, Senate Bill 838. So we have some summary information there, and actually highlighted for the commission some areas where we see, some differences in maybe the definition of, say, administrative probation versus what the commission adopted with the 8th edition. But if you don't mind, we'll sort of maybe table that for a discussion as we go down. For community service, yep. For community service, and I'll be short on this one. It's just that I think for practitioners, it was much more visually in their face than they've been used to. But it's not something that's new. As I note here on the slide, the commission has had these policies in place for a long time. The commission has had a responsibility to have guidelines for economic sanctions, sort of embedded in those economic sanction guidelines for fines and other economic sanctions like restitution. We also have seen over the years community service, and sort of thinking of community service in lieu of a fine, where you'd have a person who might warrant a fine but wouldn't be able to pay it. And so you could think about the use of community service in lieu of that fine. And so in our discussions, some takeaways were just making sure individuals recognize that in level B and A is where the commission really focused in on this. And also you see it a little bit more prominently on the matrix, maybe than what you were used to. Level B has the probation recommendations, and we see that sort of as the primary recommendation, but also included in level B is a recommendation about community service. And you'll see in the parentheses on the matrix, that's where we make note of it. But of course, if someone's using SGS Web and any of the things that I'm talking about, they will have a guideline form that includes all of these recommendations. The other area, and it's new, and so it generates more discussion than maybe what you'd expect, but it's because it's sort of novel to the guidelines, and that's the expanding of restorative sanctions in level A, and a real focus to say these are sole sanctions rather than in addition to some other alternative. So what I mean by that is saying, if you're fining somebody in level A, that's the sanction, that you're not placing them on probation and ordering a fine. So that was a real focus of the commission, to think about those sort of separate and different than level B and moving up. But one of the areas that we spent a lot of time discussing was trying to promote community service as a sole sanction. But unfortunately, under Title 42, Section 9721, community service is not a sentencing alternative to the court. And, we didn't want to come to a place within the guidelines in which we recommend a sentencing alternative that doesn't exist. And so what the commission did in the end was define out at level A the use of administrative probation. Now, while that's not defined in 9721, it's sort of, like a practice that we've seen throughout a lot of counties, that folks end up on administrative probation caseloads. And the idea is that it's just, less supervision. And so under level A, we had to really sort of expand to make sure individuals understood that in that space, if the court wanted to do community service, they'd have to order probation and do it as a community service as a condition of probation. But we really wanted to make sure they understood that the commission's intent here is that this is not general supervision. This is very limited supervision to only that which is necessary to carry out that order of the court. And so I think we had a lot of positive conversations around that. But that's one of those areas that we'll have to continue to tend to as we move forward to make sure people understand. I think this might be my final area for the sentence recommendations. And as you can see under my first sub bullet there, I say this generated a great deal of discussion. And it really did. And it did consistently throughout all of the sessions where two things came up. One is well, let me step back and I'll read the second sub bullet there to say that while the commission under the 8th edition expanded its requirements around reporting of reasons for sentences. The idea that the court is to state reasons on the record is not new. And that's not something that the commission did. And that's not our space, right? We make reference to the requirement of reporting of reasons on the record. I think what we found in our discussions with counties is that maybe we got sort of as a state a little laxed between the distinction of stating reasons on the record and the reporting of reasons to the commission. And so we really worked hard to distinguish those two. And that's where you see here on like the third sub bullet and fourth sub bullet that, when do the courts have to state reasons versus when do the courts have to report reasons to the commission? Because we had a lot of conversations, and this was really all generated out of the inclusion now of reasons into the text of the guidelines. And we heard a lot, from courts saying, well, now that I now have to put a reason on the record for my sentence if it's an aggravated or mitigated. And my response in the sessions I did was, should always have been putting a reason on the record. And so, I put the citations here, and I made sure to make, individuals aware that that's not a commission thing. That's the rules of criminal procedure. The person, when the court's sentencing, it doesn't matter whether it's a standard range, aggravated, mitigated, or a departure, the court is articulating the reason for their sentence. We, staff, are not in the business of saying whether it's a good reason or a bad reason. We are just saying that reasons should be reported. The other part and the real clarification for us in the conversations was, when does the court need to report the reason for their sentence to the commission? And I think, it was sort of surprising initially to me as we were going through the counties. This inclusion of the listing of reasons brought this discussion up. And I'm glad it did, because I think it helped us reinforce these existing policies and make sure that we're really explaining those. And the expansion then was, well, obviously for any sentence of murder 3, we're requesting a reason to be reported to us. And then for any aggravated or mitigated sentence, that's an expansion where the court's now reporting a reason to us. And of course, consistent with the past, all departures are reporting reasons to us. So, it was a positive discussion, and we had a lot across the state. The final bullet that you see here is just a reference to those listed reasons. And I think one of the areas that we heard a lot from counties, and we wanted to make sure they understood, was while the commission adopted those reasons in the text of the guidelines, they're clearly not the only reasons there are for sentences, right? It's a place where courts can look, and it might be helpful in many cases, but it is not an exhaustive list of reasons. And that's actually in the text of the guidelines that this is not all of the reasons, but we had to make sure we were reinforcing that. Judge?
Oh, I'm just going to jump in because for the new members, we went back and forth on this because we felt that exactly what Ryan is saying would happen. That people are going to say, well, if you put so many in, is it all inclusive or not? And the decision just made was, from a judicial perspective, I think the judges just said, we decided we'd put in as many as we could to help everyone. But that is not unexpected. We anticipated those questions. So I think the staff knew that question was going to be coming.
Okay, I'm going to keep moving here. I have maybe about 15 more minutes, if you can indulge me for that much longer. As far as prior record score, the discussions around prior record score are probably, we probably didn't have enough time to explain it to people, and we understood that going out, right? We saw this initial effort, and I think Bobby refers to it as sort of phase 1 of implementation, which was this ground deployment to the counties. What we tried to do was to highlight the policies and give some examples throughout so that folks could start to understand a little bit of the nuances under the new prior record score. But one of the things that I wanted to mention here, and it's the top bullet of the slide, is that we really do see this area as an area that it's going to require consistent and reoccurring trainings and discussions on. And one of the things that's also true is that until you kind of get into it and you get all of those criminal histories and those busy criminal histories, that are 12 pages long and out of state and, all of that. It's, that's where really we're going to get into the details and working with counties and understanding some of these things. I think what a broad takeaway, at least I think from the unit and certainly from myself, was for those like sort of non-complicated criminal histories, this new policy is streamlined and it is simpler. And we felt that going out, and we've certainly said that. But as the unit worked and did examples with practitioners, they heard that as well. And I know that recently I've done a few sessions with the District Attorneys Association and Institute, and they did a number of like sentencing vignettes, and they said, they think it's working easier in those areas. And so that's a real positive just from an application standpoint. Of course, there was a lot of policy decisions built into the prior record score about, reducing the impact and so forth. But for the purpose of this discussion, it's just to talk about more of the application of it. Some areas that came up were, I think this makes sense and staff sort of anticipated it. The crime-free period, we had it under the juvenile lapsing, so it wasn't new in that sense, but anything under the adult conviction was new to individuals. And so it created some opportunities for discussion. Things like, would technical violations of parole and recommitment impact a crime-free period? And I have to thank the commission for the text of the guidelines that you adopted, because for us, from a staff perspective, we could point to the text and it's pretty clear that it's not going to impact their crime-free. And so, those are the questions that kind of come up, and you have opportunities to point to the references and the text of the guidelines. Other areas were just, making sure people understood like what's initial release. Again, if you look at the text, I think it's pretty clear, but individuals that ask, well, what about work release? If someone's out on work release, and back and forth and back and forth. And if you look at the text, it's, out on parole, and that work release wouldn't be parole. Or if someone was, for example, I don't know that we do furlough so much in Pennsylvania, but someone was furloughed to go to, a medical appointment or something, that's not a release to the community. Excluded offenses, clearly a change in practice is that if someone's coming through for a DUI, we don't consider any of their DUIs in their prior record score. And so for some that was, they had to sort of wrestle with it in their mind. But these are those areas where we, from a staff perspective, are going to have to make sure we're just sort of tending to this so that there's the correct application of the guidelines moving forward. The second bullet under the excluded offenses, and this one came up, pretty regularly. And actually yesterday I was in Pittsburgh and did a session with the DA's Institute, and it came up again there, where we talk about second and subsequent offenses, which is not something new to the prior record score policies. A little bit of maybe an expansion of it, but again, another opportunity to talk about these policies with practitioners. And particularly with possession with intent to deliver, the commission talked about, anywhere in which the grade of the offense or the statutory maximum has increased, then you would not consider that prior criminal conviction in the prior record score. Well, for possession with intent to deliver, as an example, 780-113A30, if a person's convicted of a second or subsequent under section 115, it doubles the statutory maximum for that offense. And so as we were instructing about these policies, we would use an example to say, if you have, one prior PWID and you're coming through court for a second, then you wouldn't consider that former PWID in the consideration of the prior record score, because it would increase the statutory maximum. It generated a lot of conversation of like how counties charge offenses and so forth. And certainly that's not our space to talk about charging. But what I wanted to point out here is that in addition to that prior record score policy, the commission changed how they assigned offense gravity scores for these offenses. And so historically, the commission didn't have a separate and distinct offense gravity score for a second or subsequent offense. But in the 8th edition, we do now, and it's, say, 1 OGS higher as an example. So from a sort of technical standpoint in talking to counties, we've been talking about, well, when you're using SGS Web, you will see a 30 and you'll see a 30 second and subsequent. You should be selecting the second and subsequent if that's what it is, because that allows for the statutory increase. and it will increase the offense gravity score. But also keeping in mind that you're not to be considering that prior possession with intent to deliver. So there was a lot of conversations about, well, what if we don't charge it this way or that way? And anyway, it's just the talking point for us in looking at the guidelines was to say, we really want individuals to be, one, using the SGS web, two, selecting the second and subsequent, and making sure that they're not including that prior possession with intent to deliver in the consideration of the prior record score. And then finally on this slide, this is just a reminder because it gets to like the broader discussion of how individuals view coming to a prior record score. And one of the changes with the 8th edition is that we no longer look at all of these distinct judicial proceedings or these distinct sentencing events in which we apply the prior record score policies to. We just look at their entire criminal history. And we say, you know, was there a commission and a conviction of an offense prior to the commission of the current offense in which they're in front of the court? And so, you know, that was a change for individuals because they no longer need to focus in on grouping all of these, you know, sentencing dates together and figuring it all out. But one of the other things that was a change and it became a little bit more clear as we worked through these sessions was in the old policy, we talked about you'd have a commission and a conviction before commission, and you're sentenced on that prior conviction before you're sentenced on the new conviction. And so in this prior conviction world now, it's very simplified that you look back and say, did you commit it and were you convicted before you committed this offense? And so, you know, we're sort of breaking down that practice of individuals looking, one, for sentencing events, and two, sort of having to at some point maybe calculate in whether or not a person was sentenced prior to the sentence on the current offense. So maybe more than you wanted there, but I just like saying commission and conviction before conviction. So the final thing that I'll mention here is the judicial proceeding considerations. And again, sort of consistent with what I've said throughout, new and an opportunity to talk about these and what they meant. The three areas that we focused in on were, you know, multiple sentences, so concurrent and consecutive. What's a court going to do there? Promoting the consideration of programming, whether it's at the DOC. So if a person's looking at a sentence in the state prison, you know, making aware that there's all sorts of programs that are there. And while the courts cannot sentence them to those programs, you know, there could be a recommendation, or for the parties when they're negotiating, particularly for the DA, you know, you can waive eligibility. You can open the door for these individuals for programming when they get to the DOC. And then at the county level, while the options may be more limited and maybe not as well defined, but thinking about reentry supervision at the time of sentencing. You know, what's this individual looking at? If it's a county jail sentence, are there opportunities to get them into treatment, whether that's drug and alcohol treatment, outpatient, inpatient, what it might be, but just making them reentry eligible so the court has flexibility to release prior to their minimum to those reentry type programming. And then the final thing that you see there is the term of probation not exceeding 5 years as a consideration. And this is not necessarily new. It's under the 6th Amendment to the 7th edition, the commission had built in some general recommendations about duration of probation, but this was sort of pulled in under the judicial proceeding considerations. So the final thing that I'll say here is the final two bullets, and I'll do them in reverse order, actually. We really had to drive home the difference in language here. You know, when someone's convicted of an offense and a person's figuring out the offense gravity score and their prior record score, they're receiving a sentence recommendation, right, for that particular offense. When we talk about these judicial proceeding considerations, they're on the entirety of the sentencing hearing, so they're more global in that sense, right? It's not focused on an individual offense, on the entirety of the sentence. And it says considerations. And in the text, it says to encourage the court to consider. So we really wanted to make sure that we were providing that information to the parties and to the courts, because the commission debated this label for a really long time. And it was clear that it's not a recommendation and it's a consideration. And as such, it's also not going to necessarily impact conformity to the guidelines. That it's a starting point that we've, sort of incremental approach to getting these issues into the guidelines and seeing how they go. So I think there were some general concerns initially about consecutive or years of probation, but I think we did a pretty good job of making sure they understand that it's a consideration, not a recommendation, and it's not about the conformity to the guidelines. It's just a starting point to begin to maybe think about what to do with those types of sentences. So happy to take any questions, but I think I'm hitting my timeline by our executive director.
All right. Thank you, Ryan. The next presentation will be by the unit manager of the Applications and Information Technology Unit, Christy Bundro. I'm happy to share with you that rather than calling our next gen application, that we've been working hard to find a term to be used and a branding to be thinking about refreshing that. And we're now going to be referring to it as the Commission on Sentencing's Records Exchange, or CASER, not to be confused with the federal version of PACER, but CASER, Commission on Sentencing Records Exchange. So with that, I will turn it over to Christy.
It's going to be my big announcement at the end. Thanks, Matt, and good morning, everyone. So over the past 2 years, Commission staff have been working toward a complete redesign and rebuild of the SGS web application. So that's what we use, what the courts use in order to generate the sentencing guideline recommendations and submit sentencing information to the Commission. Back in 2022, we actually worked with a company called JMT Technology Group, and they developed an application designed for us for the new application. And then in July of last year, we started working with the Infomatrix Corporation to actually build the new application. So over the next 10 to 15 minutes is what I think I have. I'm going to provide an overview of that project that we're doing with Infomatrix to build the new application and show you some of the progress that we're making. Sorry, I have a lot of papers up here. Okay, so what we're calling the SGS Web Next Gen initiative is actually broken down into several phases, and we're working on phase 1 right now. The goal for this phase are listed on the slide here. So we are modernizing the technology and the user interface. The application was actually built back in the early 2000s, so the technology is outdated. As you can imagine, the interface is pretty outdated. So since we're completely rebuilding the application, the first goal is obviously to replicate the functionality that we have available in the legacy application. The new application will support the 8th edition sentencing guidelines, resentencing guidelines, and the sentence risk assessment instrument. It will not support previous versions of the guidelines, so the legacy application will remain operational to support the older editions of the guidelines. And then in this phase, we're also going to be implementing an offender-centric view of the data, which we don't currently really have in legacy application. We're planning to automate the prior record score determination. And then we're going to be leveraging more data from AOPC's CPCMS system in order to streamline the guideline generation process and to reduce some of the manual data entry that occurs today. So once we complete that first phase, we do have plans for additional phases. In future phases, we want to go a step further and use additional data from CPCMS in order to populate the sentencing screens to further reduce duplicate entry of data between our application and CPCMS. We plan to add some bulk update features to help out users. Right now, only folks with access to JNet can actually access SGS Web. So we want to extend access to non-JNet users such as public offenders. The Commission has a mandate to provide interactive sentencing outcome data to support sentencing decisions. We're not sure exactly what that's going to look like, but we will be exploring that in the future phase, along with approving county's ability to monitor reporting compliance to the commission. And then for the third phase, we had been planning to build kind of fully functional modules to support the recently adopted parole guidelines and recommitment ranges. But we have been working with the parole board on this, and they've done a lot of work in their systems to support those guidelines and recommitment ranges. So at this point, we don't think we necessarily need fully functioning modules, but we do need to still automate the exchange of data with the parole board and also provide some access to that data in our application for reporting and analysis and that sort of thing. And then lastly, we've been talking for a while about building a website or an online tool that members of the public can use to calculate a sentence recommendation. So again, not sure exactly what that looks like, but we'll figure it out when we get there. So as I mentioned, for phase one of the Next Gen initiative, we've been working with the Infomatrix Corporation. We negotiated a service purchase contract with them for $920,000 for phase one and started working with them this past July. Their team listed on the left have been working very closely with commission staff, specifically the folks listed on the right. So as you can see, it's a pretty complex project that requires a very technical skill set and a lot of people working on it. As far as the project schedule, there have been a few delays, which is pretty typical with IT projects. The top bar on this chart represents the original schedule from our contract with Infomatrix. So we were expecting to be done with the bulk of the development by the end of April so that we could onboard some pilot counties starting in May and then hopefully rolling out to the rest of the counties by the end of 2024. Due to some staff turnover on their team, as well as just like project complexities, they've requested a few extensions that have put us about 3 months behind on the original schedule. So that second bar is the revised schedule. So at this point, we're looking at starting our pilot in August and then rolling out to the counties toward the end of 2024 into 2025.
So is that, at those timelines, that's just the phase one timeline? that
Yes,
you're looking
just
at?
the phase one timeline.
Do
Yep.
we have any estimate? Phase,
Not at this point. So we would, as soon as we finish kind of this phase one, start rolling into phase two. But we haven't looked at any like budgeting or anything like that for the project yet. So, so far, so as far as budgeting though, so far this extension has been cost free. Like they haven't requested any additional money for the extension since most of the issues have been on their side. And then also, since we implemented support for the 8th edition into the legacy application, there hasn't, the delay has been low impact for us, other than the project taking longer than we originally anticipated. The next few slides are detail kind of the progress that we've made with Infomatrix so far. We obviously started with the foundation of the application. So we set up the framework that we needed to support the development. We established standards for functionality, such as error messages, basic grid features, audit history, that sort of thing. We've implemented the main navigation menus, the login page, system information messages, and then also implemented the architecture to support user permissions. Since we completed those tasks, we were able to start building the actual features and functionality that users interact with. So to this end, we have created the process to integrate with JNet and AOPC to import offender, case, offense, and criminal history information from CPCMS. We've implemented a feature to manually create an offender and a case in a judicial proceeding. We've implemented an offender search screen, an offender dashboard, and a sentence dashboard. And we're currently working on kind of the most important, what I would say are the most important screens are those that users can use to create the offenses in order to generate the OGS PRS in order to actually generate the sentence guideline recommendations. So just to give you an idea of what the application looks like today, these are a few screenshots from the legacy SGS web application and the existing guideline form. And then this is a screenshot from one of the screens we've developed for the new application. So you can see by just looking at it, it has a much more modern design and feel. This is the sentence dashboard, which users will be able to use kind of as a starting point to managing cases in the application. And then this is the offender search screen that will allow users to find a specific offender and by using a variety of search criteria. And then this is the offender dashboard. So it's like one place where you can go to see all the information that we have about a specific offender. And then this is a screen that's used to manually import data from AOPC. So in this application, we are planning to have a data feed from AOPC so that the data should already be available for the user to start a case. However, sometimes those things fail. So this gives the user the ability to manually import the data. And then this last screen is just an example of a data entry screen. So this one is for creating offenders, but it was just kind of an example of another screen that we've developed. So we do have a lot more work to do, but so far I think we've made pretty good progress. And then this was going to be my big announcement of the new name of the application. So rather than calling it SGS Web Next Gen or SGS Web 2.0, we did decide on the name Commission on Sentencing Records Exchange, or CSRE, or CASER is what we're referring to that as. We decided to go with a different name just to really differentiate it from the existing system, since SGS Web will be hanging around for a while to support the older editions of the guidelines. And then also SGS stands for Sentencing Guideline Software, and the Commission's mandates have really expanded over the years beyond sentencing. So we wanted a name that kind of represented that full enterprise scope of what the application is going to be. So we did work with a graphic design company to design the logos that you see here. Matt, I know this is your baby. Do you want to talk about the logos?
So we re-engaged with a company called Visual Research with a gentleman named Neil Cotter. And Neil and his group were the group that designed the sentencing matrix that we're using for the 8th edition guidelines, was instrumental in our work with us on redesigning our website. So we're really happy to continue that engagement with Visual Research. And as Christy noted, I think that the idea here of records exchange, not just sentencing, it's a broader expansion of that, which will include parole and other aspects, and really wanted to convey through this image the idea of movement of information. And so, we're going to be providing the software will generate the sentencing guidelines, will develop risk assessment recommendations, and et cetera. And then ultimately the commission will receive data through this application that we use for research, for reporting, for the annual report, and so forth. So that was our intent with the design, and to keep it really simple. Of course, we see that being used by Bobby's unit, the education and outreach, for his efforts, as well as the branding for the actual application. Again, CSRE or CASER, Commission on Sentencing Records Exchange. So we just displayed, we asked the artist to provide lots of different colors. Those colors conform with the colors that are being used by Christie's group in the design that came from our original consultants working with us, where red is like an error message, orange a warning. We'll probably utilize the dark blue, and the black, not so much some of the other designs, but we'll see. So we have a lot of flexibility in the approach that we take for when we're disseminating, sharing information with our stakeholders and with the county.
I think my favorite is the one on top, actually. So that's all I have. Are there any questions about the progress of the project or project itself? Okay, I'll turn it back over to Matt.
All right, thanks, Christy. I think that, we've been doing Ryan and I, some orientation of new members, and we've been talking about how we're at a good point because of this shift from development of policies to implementation. And I think one of the things that I've just come to realize is that it probably means less heavy lifting for commission members, but what you can see is clearly a lot of work for staff. And so Christie's team, it's a level of expertise that is beyond me, this technical side, and I'm learning a lot about how complicated, challenging that work environment is to translate business process rules into these technical specifications that drive these web-based applications. So I'm really encouraged by what I've seen so far in terms of, again, the cleanliness and the user-friendly approach that's being generated. Really excited for that to be rolled out. And I think I'll just make one quick plug is that, what I've also learned is in this tech space, it's very expensive. So these phases cost a lot of money. And this goes to some efforts that Representative Krajewski and I are working on and related to our most recent budgetary requests that we discussed at previous commission meetings that's asking for an increase for our appropriation to support efforts like this, to support, of course, our other efforts that are ongoing as we provide an infrastructure to support the 8th edition guidelines, the parole guidelines, resentencing, recommitment, all these varied responsibilities that we have. We certainly received some funding from JRI 2 initiative, but those funds have not been as much as anticipated. So we can talk more about the budget issues during the business meeting, but just wanted to point out, you could see the level of engagement with staff at trying to reach out to all 67 counties from the education and outreach effort, and then the level of effort that's going into designing and developing these new web-based applications that I think it's been highlighted, but for new members, I'll just mention this also. When I started at the commission 6 or 7 years ago, there were only 2 people in that applications and information technology unit. We relied on almost all updates to be done externally by a vendor. The challenge in that space, and Christy certainly could weigh in, is that you're at the mercy of other people's timelines and priorities. We now have a much more robust staff of 4 full-time individuals and Christy managing that unit. So a majority of the work, including the work of updating the legacy application to support the 8th edition, was done in-house. We're able to, when something pops up that's a challenge, work internally to solve that. This huge enterprise project, we are relying, of course, working with consultants, but a bulk of the work is actually being done by commission staff. So we're really proud that we have that in-house now. I think that we'll see those benefits in the coming months when this new application is released, but we're already seeing it by being able to update the SGS Web existing application to support the 8th edition, to support things like risk assessment, and then with Christie's leadership, really thinking about ways we could leverage our partnerships with JNet and AOPC to have smoother transmission of data and all those others. So I think the commission is really in a great place as it relates to the applications and information technology unit. And to just comment on Chairman Fox's question, I wish we could do all of this quickly, but I'm learning it's really, really complicated, and we look forward to, moving to the additional phases, but then we'll have to also discuss, of course, resources and what we have available, if that could be done in-house. I think that just highlights for me one additional area of those standing committees. These are some of the conversations that can be had with those committees, talking about prioritizations and what timelines look like, talking about setbacks or delays, and really communicating. So big thanks to Christy and her team. And as you saw that when she listed those members, this is a huge effort, not just from Christy's team, but Bobby's unit, education and outreach, Brett's unit and research and data analysis. Everybody's involved because we're designing in that not only the data elements, but how that data will come to the research group in terms of the database. So there's a lot of discussions that are going on from a policy side, from testing and et cetera. So big thanks to commission staff. I think the last presentation that we'll have time for this morning, I'll mention some comments about the veteran study shortly, will be on the sentencing risk assessment tool. I think this is the second or third formal presentation back to the commission about utilization or implementation of the risk assessment tool. So our unit manager, Brett Miller, is joining us remotely. So I will turn it to Brett, and Jordan Zvonkovich from the research and data analysis team is here also. We'll be presenting with Brett. So Brett Miller.
Good morning, everyone. So today we wanted to take some time to take a look back at the implementation of the sentencing risk assessment. So I'll be presenting, as Matt said, with Jordan Zvonkovich, who is our lead analyst in the research and analysis unit. The risk assessment hasn't been a big topic of discussion for us over the last couple of years. But for those members that have been around for a while, you'll remember that the development process that went into the risk assessment was very long process, years in the making, very deliberate, and in some cases, a very public process with several interim reports developed throughout the way, and many public hearings throughout the state during that development process. So the risk assessment went into effect in 2020. So just so happened, similar to a lot of the JRI2 programs at DOC, the risk assessment went into effect during the COVID pandemic. And so it didn't necessarily affect the implementation, but it did affect in some ways our ability to look at that data and to be able to gauge sort of how the implementation was rolling out, what sort of impact it was having, and how judges were implementing that assessment. So now we're about 3.5 years in and a little bit separated from COVID. So now this is a good chance just to go back in, take a look, and see how the implementation process has been going. And then hopefully at the end, we can get some discussion going with the judges and just sort of get some of your opinions and assessments of how you feel the risk assessment is working in practice. And if there are any changes we can make, maybe in SGS Web, to better collect some of this information or to make it more effective on your end in the courtroom. So just to start, I'll go back through some of the background of the statute and what was being asked of us in the development of this risk assessment. And this all started back in 2010. So Act 95 of 2010 sort of laid out what our mission was in developing this risk assessment and really what the purpose of the assessment was meant to be. So it was never really meant to direct judges to change their decisions in any way, but rather it was meant to be just more of an aid to sort of help assist in gathering more information in the judges making those decisions. I'll just briefly highlight a couple of elements of Act 95. If I can change slides here. So obviously the Act asked us to adopt a risk assessment. And like I said, the goal was to help the court determine the appropriate sentence for felonies and misdemeanors. And the Act says that the assessment may be used to evaluate the relative risk that an offender will reoffend and be a threat to public safety. It says the assessment may be incorporated into the sentencing guidelines. We haven't directly incorporated it into the sentencing guidelines. At this point, it's just more of an addition at the sentencing phase. Risk assessment may be used to determine whether a more thorough assessment is necessary or whether the court maybe needs to go out and collect additional information in the form of a PSI, drug and alcohol assessment, etc. in the assessment, maybe an aid to help determine appropriate candidates for alternative sentencing. So that could be triple RI, it could be boot camp, intermediate punishment, or maybe some of the JRI2 programs that came about around the same time. And then finally, Act 115 of 2019, which was the JRI2 legislation. This is mostly with relation to the state drug treatment program, and with the idea that the risk assessment can be used to identify appropriate candidates for some of these new programs, such as state drug treatment program, motivational boot camp, and triple RI. So the commission staff went to work right away in 2010 to start developing the risk assessment. And as you can see, it took a full 10 years before that assessment was implemented. So throughout the 10 years, there were sort of 3 different phases of the development process. And those first few years were really more of what I would call an exploratory phase, where commission staff were going out and looking at other existing risk assessments, looking at potential scales, potential factors that could be included in a risk assessment that would be appropriate for Pennsylvania. And then thinking about how to categorize those risk scores, which could be high, medium, and low. If you have high, medium, and low, do you share that with the court, or do you just make a recommendation that someone may not be typical risk? And then later on in that 2013, 2014 timeframe, the commission conducted focus groups in 4 different counties. So basically that looked like going out into those counties, talking with them, thinking about how we can collect this criminal history information at the county level, what sort of factors would be appropriate to include, and then sort of just the mechanics of how to make this all work in a timely fashion prior to the sentencing hearing. And then finally in 2014, it was realized that in order to collect all of this criminal history information, it would be quite an undertaking at the county level to collect all of that information by hand, on paper, on a case-by-case basis. So that was when the commission first developed a data linkage with AOPC, where we were able to directly import criminal history information through JNet into SGS Web, and then use that criminal history information to inform the risk assessment. During these 4 years, 2010 to 2014, the commission produced 9 interim reports. These are all still available on the commission website, but these were really in-depth reports, as I mentioned, talking about what is the current state of criminal justice risk assessments at that time, what other jurisdictions are using risk assessments and how are they using them, and just really detailed just exploratory research into the world of risk assessments. In 2015 and 2016, we sort of hit the ground and really trying to figure out how to actually implement this concept and how to develop our own risk scale. So the initial version, or several versions of the risk assessment, actually had separate risk scales for every OGS category. So we had 14 OGS levels. We would have had 14 separate risk assessments for each one of those OGS levels. We developed 3 interim reports during this time period, looking at the data that was being used and really spelling out that entire development process. And as we moved into the final phase, 2017 to 2019, that's when we realized it makes more sense to have a single risk scale. And that's really when we started to zero in on what became our final risk assessment tool. So the final model went through several iterations during that time from 2017 to 2019. In the meantime, we were producing additional interim reports, 6 more reports, and going around the state and getting feedback through several public hearings all around the state. We actually conducted 19 public hearings just in that time window, 2017 to 2019. And so we heard a lot of feedback. incorporated a lot of that feedback that we got over several iterations in a short amount of time. And for a while there, we were coming back every 3 months at these quarterly commission meetings, slight tweaks and new models to propose. And so there's a lot of work happening in a short amount of time. And then finally in 2019, the commission members sort of settled in on what became the final model. We sent all of our data, all of our research out to Carnegie Mellon University and had an independent external review done by CMU. And they provided some additional information, some additional feedback in terms of which factors should be included, who the assessment should apply to. We incorporated one more round of revisions, and then finally in 2020 actually was the implementation of the model that we have today. From the final risk model that went into implementation in 2020, we ended up with 7 different risk factors. So the factors are gender, the age of the offender, and the age that we used was the age at the time of the assessment of the risk instrument, the current conviction offense type, the number of current convictions, the number of prior convictions, and the types of those prior convictions, and then finally, whether or not the offender had any prior juvenile adjudications. So each of these elements is assigned a point value. You tally up all the points across all the elements, and we end up with a risk score, which can range anywhere from 0 to 18 points. There was a lot of discussion during development about how to set cut points that would categorize this risk scale into low, typical, and high risk. So there were several proposals, but in the end, what we decided was that the low risk category would be sort of 1 standard deviation below the mean. That group would be low risk. So it turned out that the scale follows roughly a bell curve. And so 1 standard deviation below turned out to be roughly in the range of 17 or so percent. It turned out to be 18% of the sample in our development data. Sort of the middle standard deviation, you could say, from the mean was sort of typical risk, and then high risk was actually set to be 2 standard deviations above the mean, which works out to roughly around 5% is what we would expect to be in high risk. And in our construction data, it turned out to be 4% of that group that was high risk. So in that middle level, that's really where the majority of offenders are expected to end up in the risk assessment, is in that typical risk area, which is the 5 to 9 points on that risk scale. So after setting these
Brad,
set points,
just a real quick correction. The typical should be 5 to 11. There's a typo there. Sorry about that.
sorry. So after setting these set points, the risk assessment then was deployed through SGS Web. As I mentioned, we had the data linkage with AOPC. So everything on the SGS website is fully automated. We bring in that criminal history from AOPC convictions, and applying the scale, we come up with a risk score and then the risk classification. And then what the user sees on the other end, they either get a recommendation for additional information or they get no recommendation. So the user and the judge gets no indication that an offender is low risk or high risk or typical risk. If an offender falls into that typical range, which is about 80% of cases, there will be no recommendation for additional information. Then the low and high risk will get that recommendation. And the idea behind recommending additional information is that, you know, if you have someone who's on the high risk side, maybe you can go get a PSI, go get a drug or alcohol evaluation, and maybe you can determine that this is someone who is better suited for one sentencing alternative versus another. Maybe someone who needs treatment when they go into confinement. And on the other hand, on the low risk side, collecting that additional information might be an opportunity to divert someone away from confinement. Maybe you could decide, oh, they could be better served in the community, better access to treatment, what have you, based on the findings of that additional information. So after providing the risk assessment recommendation in SGS Web, we attempt to collect a couple pieces of information that the idea is to give us an idea of, number one, is the court receiving this risk recommendation? And number two, if they're going out and collecting additional information based on the risk assessment, what type of information was that? So that we have a drop-down list where the user can select whether they went out and they got a PSI, risk needs assessment, etc. And with that, I'll turn it over to Jordan, and he'll discuss some of the actual data that we've seen since implementation and what that looks like.
All right, thanks. All right, thanks, Brett, for the context there. This first slide, we have the effective implementation date and the statutory language about that listed at the top. It shows July 1st, 2020, offenses or convictions for offenses committed on or after that date will receive a risk assessment, assuming it's a non-DUI offense. So what I'm going to be covering today is a review of the last 3 years or so of our data that we've received for the risk instrument. We have about 106,000 cases combined over those 3 years. And on this first slide is just the number of risk cases that we're receiving every month. And the only thing that we want to highlight here is just sort of the ramping up that occurred at the beginning of January 2021. We weren't receiving very many risk cases. A lot of those sentences were for offenses that were probably committed prior to July 1st, 2020. And if we look at then 2022, we're still seeing an increase, some more variability there, a lot of spikes on the line chart. And it's really the same pattern for 2023. We suspect those spikes are sort of waves of delayed reporting because for this, we used a monthly extract of our data as opposed to the actual date that it was sentenced. So that big spike in May 2023 doesn't mean that every one of those cases was from May 2023. On the next slide here, I'm going to compare the data that was used in the construction of the risk instrument to the data for the last 3 years. So that data that we used in the construction was from 2004 to 2006, and it was for 131,000 individuals. On the x-axis, we have the individual risk score. So that's a sum of all the factors that Brett was talking about. And on the vertical y-axis, we just have the percentage of cases that fall into each of those scores. So for the construction sample, we see a pretty normal bell-shaped distribution there, with 7 being the most common risk score. Below that figure now, it is broken out into low, typical, and high risk. And as Brett was mentioning, we have about 78% typical risk, almost 5% at high risk, and 17.5% at low risk. Compared to, compared to the last 3 years of data, it looks pretty similar. We still have a very normal bell-shaped distribution there. 7 is still the most common risk score, and the distribution across the risk categories is pretty similar overall, I would say. We believe this suggests that the factors that were used to derive those risk scores continue to produce the intended distribution that we were hoping. So as Brett was mentioning, individuals classified as low or high risk receive the recommendation to obtain additional information in that case. I'm sorry, this shouldn't, it's touchy. They receive that recommendation to receive additional information. And what this is showing the percent where we actually do receive that additional information. So overall, it's 18.4%. At typical risk, it's 18%, low risk 19%, and high risk is only 21%. So there's not really the stark differences that we would expect there to suggest that the recommendation is being followed every time. So we look at the percentage of cases in a given county class where additional information is obtained. You see on the rightmost bar of that figure, the state average at 18.4%. And then if we focus on the right half of the county classes, county class 3 is about right at the state average, close to class 4 counties as well, a little bit higher than 3. And then through 5 through 8 are significantly higher than any other of the county classifications. Focusing on the left, we have the class 1 county, which is slightly under the statewide average, and the class 2 and 2A counties, which are obtaining additional information at the lowest rate.
So focusing just on that top panel really quick, you know, the design of this obviously is a recommendation for obtaining additional information for low and high risk offenders. So we might expect that the proportion where additional information is obtained, I don't know what the expectation should be, but should be higher than the typical category. Or so if 20% for typical is okay, whatever that might be, we would expect low and high to be statistically and substantively different than typical. Originally, when we did this first time, I thought they would be in excess of 50 to 75% of cases would be targeting resources specifically to the low and high. Part of this was to utilize scarce resources in a reasonable way. So we see out of those 80,000 typical, 14,000 are receiving additional information. So one of the thinking was that the best targeted use of resources when developing and collecting information in a PSI is time consuming and costly. And so the fact that the rates are the same is a question that we'll get to in a moment of why is that, and maybe the tool is not working in the way that we hoped it would to, again, target limited resources to those cases where additional information would provide the biggest bang for their buck for sentencing decisions. Not to say, again, that there shouldn't be any for typical, because this is advisory and up to the judge to make that request. But this is, from an empirical perspective, a troubling finding.
So we just looked at the county class rate of additional information being obtained. To dig in a little deeper, we'll present some summary statistics here for individual counties. Again, you have the state average at the top, 18.4%. This ranges from a low in one county of 0.19% all the way up to one county in which, well, multiple counties in which 100% of the time they receive additional information in this sample of risk cases. For the lowest 3 counties, it's all of them are under 0.25% of cases they're receiving additional information in. And for the highest 3, they're all above 96%. So we're really just highlighting that there's wide variability here. There's a wide range of practices in obtaining this additional information across the different counties. And I'll probably go through these next slides kind of quick because it is the same information presented graphically now. So the red line there is the state average, and the blue line connects a series of 67 data points, one for each county, and the rate at which additional information is obtained. If we focus there on the shaded portion of the blue line, that represents 20 counties where additional information is being obtained in less than 5% of the cases. But on the other end of the spectrum, there are 11 counties where additional information is being obtained in over 75% of the cases. So again, just highlighting that wide variability, and that probably isn't a surprise. It could be used as a any research presentation. That could be one of the conclusions. So the last thing that I looked at was risk classification and its relationship to the conformity of the sentence from the sentencing guidelines. For ease of discussion here, we've combined below and mitigated and above and aggravated. So we have a 3-category look at conformity. Focusing on the bottom overall, we have about 68% of cases in the standard range, 5.4% above and aggravated, and about 26% below and mitigated. The probably doesn't mirror the normal distributions that we present. This is a obviously different sample that doesn't include probably our highest offense category, which is DUI. So probably why we're seeing a little bit lower than 70%, which is closer to where we historically are for standard range sentencing. Looking at typical risk here, the pattern is pretty similar to the overall, and that's not unexpected. The majority of cases are in typical risk, but we do see differences at low and high risk. Starting at low risk, we have a greater percentage of cases that are receiving standard range sentences, and a greater percentage of cases that are receiving about the same percent of cases that are receiving above and aggravated, as slightly and a lower percentage of cases that are receiving sentences below or in the mitigated range of the guidelines. The opposite relationships are true for high risk. So we have lower percentage of cases in the standard range, lower percentage cases above and aggravated ranges, and a higher percentage of cases below the standard range of the guidelines and the mitigated range. There's a couple of things to keep in mind. I think one of them is sort of the structure of the guidelines. So at guideline level 1 and guideline level 2, there are a lot of cells where the standard range includes RS. So it's not possible to sentence below the standard range for those. And likewise on the upper end as well, there are a number of cells at guideline level 5 that include the statutory limit. So they can't be sentenced above the standard range. The other thing to keep in mind is something that Brett alluded to, which is that the sentence risk assessment is not related to sentencing recommendations. It's only related to that recommendation to get additional information. With that, I will pass it back to Brett to summarize some of the main findings and raise some points of discussion.
All right, thanks, Jordan. Yeah, so I've got just a few points I wanted to highlight, just sort of in summary here, and then hopefully turn it to the members and just get some feedback on what you guys are seeing. First, just from a purely numerical standpoint, the risk assessment model is working as we expected it to. So this is a good sign. But what we're seeing is the actual scores, the adding up of those risk factors. It has almost the identical distribution to what we had in our construction sample. So in that sense, the model is working really well. The rates of offenders falling into those low, typical, and high categories, again, same thing, almost identical to our construction sample. So like I said, that's a really positive sign that the work we did on the front end in development, we developed a solid model just from a mathematical standpoint. So that's good to see. Next, another positive outcome of this analysis is just to see that the risk assessments are being generated for all cases. So that's something we weren't sure of, but looking at SGS Web, we are pulling in that AOPC data for every case that is eligible for risk. We are getting a score generated for every case. So again, on the nuts and bolts software side, things are working as expected and things are working well. As a caveat to that, it is difficult to tell whether or not the judge is actually seeing the result of the risk assessment prior to giving their sentence. That's something that we can't really tell from SGS Web. We've got a timestamp of when that score was generated, and we know when the sentence is given. What we don't know is if anyone is presenting this information to the judge prior to actually imposing that sentence. Second, the way we're asking this information in SGS Web, to me, is a little bit confusing. And I think even inside the office, we had like a little internal debate about what this question is actually asking for. So I put it up on the slide here, but the question in SGS Web says, did the court receive a recommendation for additional information via the risk assessment prior to sentencing? So the question is this asking the court whether they received the risk assessment? Is this asking the court whether they got that recommendation for additional information for the low risk or high risk? Or is it asking them if they did anything based on the risk assessment? So I'm not sure if this is the most clear wording, but in the end, when we go and look at the data, as Jordan showed, it seems people are answering this question in different ways in different places. So certainly counties are probably using the assessment in different ways, but just with the phrasing of the question, I'm not sure exactly how to interpret what they're answering. So if someone says, if you see a risk assessment and it doesn't give you a recommendation, do you say yes or no to this question? And that's what I'm not quite sure of. So maybe we can get some discussion on that in just a minute here. And then finally, the point that Jordan and Matt both highlighted was the fact that the risk category in that recommendation doesn't seem to have much of an impact on whether or not the court actually does go out and get additional information. It doesn't seem to have any impact at all. In fact, counties are getting that additional information at the same rate, regardless of the risk category. So that part is a bit disappointing, but again, there's sort of some questions about the way we're asking for this information that make it a little hard to interpret. So first, do the courts have this additional information already? Did they already get a PSI? Did they already have every assessment they could possibly have? And then when the risk assessment comes up, it's like, oh, I don't need to do anything because I have everything I need already. So that's one possibility. Another possibility is it a timing issue where the judge is seeing this recommendation to get more information, but now here I am sitting in the sentencing hearing and I need to give a sentence. There is no time to go get a PSI. Maybe that's happening in some cases. And then finally, is it possible that judges just aren't even receiving the risk recommendation, not even seeing the SGS Web score sheet that has that recommendation on it? And so I think there's sort of some open questions that we still have on our end after looking at this data. And so I think a lot of that, maybe we can improve the wording of some of these questions, but just from your end, on the court side, maybe some of you could just give your experiences and what you're seeing and how you respond to these recommendations.
Brad, if I can jump, I got a lot of thoughts about trying to synthesize them. Well, let me ask you a question first. Back to that question that you said was somewhat ambiguous, where is that coming from? Is that when it's reported to SGS Web, whether we had the information or not?
Yeah, so this is the user of SGS Web, whoever that might be in the county, and they're going in
Okay.
and saying, did you present this information to the court, essentially?
All right. So I think a couple of things come into play. One is each county is probably doing what they've always done, regardless of efforts to change things here with risk assessment. So some of the counties I think that are 100%, probably always order pre-sentences, and I think that's why we see them in, that typical class so high. What I see here, and this is just anecdotal, one court in one county, I think was some people that I would guess would be high risk. There are cases where there's a plea agreement. So there becomes no need, someone's coming in here for 5 to 10 years or 10 to 20 years. There's a plea agreement and everybody agrees there's no need for a pre-sentence. So if I see something checked off on that guy who's got, prior is an RFL or a prior record score 5, something like that, I'm just thinking in my head, all right, yeah, I know why there's the need for the risk assessment or why there's the recommendation for that. And I think the flip side, and is true for the lower risk ones, and this is sort of to your point, in a lot of counties, it's plea sentencing right away. So there's not going to be that time frame. And if the person is looking at an RS to something otherwise, and I see that box checked off, I'm thinking in my head, okay, it's probably a low risk. I'm given probation anyway, so why are we necessarily going to take the time, to do a pre-sentence, a risk needs assessment, things of that nature? I think where some of the typical ones, maybe why that is higher, is some of those ones are the ones where you're on the fence. You don't have enough information, and it is this a probation case, a county sentence case, a state sentence case? I don't know. I'm just positing some thoughts to throw out to you. Obviously, I was a little on the tail end when I got on the commission with the debate surrounding this. I have my views as to whether it's a true risk assessment or not. I think it's somewhat watered down. But in any event, I just think a lot of judges probably aren't looking at that little box. And if we are looking at it thinking, okay, well, I was going to do this anyway, it's really not going to affect, what I'm going to do with the case.
Thanks. Yeah, I think everything you said makes sense, and it's sort of some of the things that we've been hypothesizing might be going on.
I can jump in and echo a lot of that. First of all, if you have a county where a significant portion of your pleas are negotiated, like in Philadelphia, you're not going to do it. And then if you go to the more serious crimes where you're giving someone 20 to 40, 15 to 30, you're not going to do it. And, then there's a question of judges just looking at it ahead of time to consider it. And I think that's, at least in Philly, retooling the judges' thought processes. But generally speaking, guidelines, and the whole system was used as an after effect. I do my sentencing, then I do it. So there's still some need, at least in my county, for some more education about the use of the risk assessment. And then we go back to what I wasn't on the commission either, the judges' feelings that they're better at doing risk than a chart or a formula or an algorithm. So, I think that's still out there.
Yeah, thanks,
So,
Judge. Yeah, go ahead, Matt.
I want to thank Brett and Jordan for the presentation. I think there's an opportunity for the education outreach unit to speak to judges in different counties, speak to the SGS Web users, and dig in a little bit on some of the questions Brett has, but also to do some education programs, again, about the purposes of risk assessment, why actuarial risk might be better than individual opinions in terms of predictions and so forth. So I think there's a real opportunity there for us to continue down to explore some of the patterns we saw. So
Could I ask a question?
Sure.
And has there been any thought now that this has been 3 years of data collection to going back and looking at these cases in terms of recidivism and new arrest to compare now to say that your higher risks are arrested at this rate, your medium and low risk are arrested at these rates? That, if that proves to have some accuracy, but then potentially the judges would maybe take it a little more seriously as a predictive tool. Has there been any thought to doing that or no?
yeah, so I think that the construction sample would have definitely been oriented towards recidivism. And that's the way that that scale was developed, was the higher the total number of points you have, the higher probability you have of recidivism. And so we group them into the three grouping. We unfortunately are still, I would say, in the infancy, because if you're going to serve one of these long sentences for the higher risk people, you're not going to be released. We can't track them. We did it, retrospectively building that data sample, and why that was from 2004 to 2006 was to ensure we had at the time, 10-year period where people could be released and we could be following them. So I think long-term, there should be a revalidation of the tool. And I'll say long-term, not anytime soon, only because it's still pretty fresh. And as Brett noted, was confirmed and validated by CMU only a few years ago as a valid.
That makes sense. Makes sense. And it might be helpful to have some of the statistics around that available to support them. They could take a look at it. Thank you.
Sure. And as Brett mentioned, we have probably way more material on our website than any person would want to look at in terms of how it was developed. But I think we can disseminate some more targeted information about how it was constructed and those recidivism rates for the different groups and why we think that's important. So we are past our time for the policy meeting, but very briefly, let me just summarize the information from Senate Resolution 196, only because I'd like the commission to be aware. For new members, every once in a while, we receive a mandate from the legislature to conduct a study. Most recently was HR 111, which asked us to look at the use of practices related to the violation of the Uniform Firearms Act. I can't remember the duration of the study. It might have been 12 months, 18 months, but when that happens, because the research and data analysis unit is only 4 individuals plus the manager being Brett, I would call it an all hands on deck approach, where we have to comprehensively evaluate and collect information from various agencies to do those studies. So we are appreciative that we are asked to do those types of studies, but I just want commission members to know it is a little disruptive to other activities that we need to perform. This Senate resolution that I'm highlighting from session 2023, again, it's not enacted, but it's calling for and thinking about asking the commission to conduct a thorough and comprehensive study on the effects that post-traumatic stress disorder or injury, military sexual trauma, or traumatic brain injury have on service members, veterans, and their families who are directly or indirectly involved in any portion or component of the criminal justice system. So not getting into all the details, we can talk about that maybe at the next meeting or with one of our subcommittees, but it is a significant lift, which would require a lot of interagency cooperation. For example, even identifying veterans, who a veteran is not in PCS data. It's not in AOPC data. So similar to the way that the Department of Corrections does this, we would have to work with the Bureau of Veterans Affairs to provide them a list and have them identify on this list of all individuals sentenced from, I think it's 2016 to 21. Let us know who is a veteran. Obviously, we would need a definition of veterans. So there's a lot of challenges from a data perspective related to this. This particular study calls for this investigation to be done in 6 months. I think this type of study would require 18 months personally. 12 months would be a challenge. So I've been in communication with the chair and the vice chair talking about how we're able to provide feedback to committee members and sponsors of this legislation to provide them with both technical feedback related to what they're asking us to do and what's feasible or not feasible, and then, of course, these timelines. So with that, I'll just mention that we've decided to sort of start on this project a little bit where we can, just getting a head start in case it does come, and that's been really helpful and important for us. We were fortunate to meet with Department of Corrections staff who walked us through programs that are available at the Department of Corrections, what data they use. We're doing a pretty thorough, at least literature review using some graduate students and postdocs on veterans treatment courts, what their principles are, where they exist in Pennsylvania, where they don't exist in Pennsylvania, what evaluations have been done about their effectiveness and cost effectiveness. We're going to make a site visit to Cambria County and meet with Judge Bernstein, but also meet with the Veterans Treatment Court provider, some county provisions that exist for veterans. So we're getting a head start, not necessarily devoting a lot of staff time to this. We're relying on, as I mentioned, graduate students and postdocs who are working with us. Brett and I are framing some questions, but if something like this were to come with a timeline of 6 months, it would basically halt all other operations from the research group, which includes collecting and analyzing data related to the annual report and many other aspects that we do. But I think it's a very important study and an important question. And I appreciate members of the Senate thinking that we could take this type of project on and do a really good job. And I think historically we've done that for other studies. So I just point that out to the commission that this could be coming. I'm not sure when it will be considered by the Senate. Professor Rago?
We actually have 5 veteran services units. So yeah, we'll be happy to collect.
And I think similar to this risk assessment tool, there is a call for identifying, not for us to create, thankfully, a tool for identifying post-traumatic stress disorder or injury prior to sentencing so that the judge knows that these conditions exist, so that the sentence that's crafted could be taking that into consideration at the time of sentencing. And DOC certainly is one aspect, but there are community programs, probation, what's available in individual communities. And this is looking for some best practices for suggestions about how to approach that. So again, we can discuss later and hopefully with our subcommittee, maybe from the research and data analysis unit. So I, again, want to thank Department of Corrections for meeting with us. It was a really productive meeting on that and other aspects. So I will turn it over to Judge Marsico to maybe call this meeting to an end.
All right. Happy to call this meeting to an end unless there's anything else. All right. Then we can end our policy meeting. I'll turn it back to Matt for further direction as to where we're going from here.
So I think we'll take a 10-minute break, come back at 11:30, which point we will begin the business meeting. And it is anticipated that after the commencement of the business meeting, we will go to executive session. And then after the executive session, return to the business meeting. So with that, I will see everyone in 10 minutes. Thank you.